My name is Jennifer Dizo, and I am a principal with the BTI Consulting Group, and I'm going to be leading today's webinar. Let's back up to the very beginning. You haven't gotten hired yet. Perhaps you are in an informal discussion with an existing client, or maybe you're actively pitching work for a new client. Either way, at some point, you know the topic of rates is going to come up. So I want to spend a little time focusing on how we are going to handle this stage of the conversation. So once again, the rapport that you've worked so hard to build up with this client or potential client, that chemistry that you have, doesn't sort of come crashing down or at least get awkward the minute you start talking about money and rate sheets. So we're going to give you 6 tactics to navigate and lock in clients through fee discussions. Now, the only question that you can be sure every client is going to ask prior to hiring you is, how much will this cost? After all, these are business transactions. The more you prolong addressing cost, the more it becomes the elephant in the room, and it leaves everyone wondering who's going to force the issue first. Take control of the conversation as quickly as possible in order to discuss your fees on your terms. This allows you to proactively steer the conversation to the points that you want to make instead of reacting to what usually turns into a series of rapid-fire questions about rate sheets. Now, I find the simplest way to do this is to simply say, I'd like to start by talking through your goals and objectives for this matter. Then we'll take some time, we'll go through what usual fees look like for this matter, and based on what you're trying to accomplish, we can probably outline some potential options and alternatives. It's a pretty simple approach. Again, it's a casual conversation. 2 main benefits to this approach. First, you're indicating that you are open to discussing costs. Again, when you don't proactively bring up fees, clients begin to feel like you're hiding something, and it immediately makes them skeptical of whatever number you're going to throw out. Secondly, this adds a little breathing room to the conversation, so you can be sure that you're going to get the critical pieces of information that you need before getting roped up into a cost that frankly may not be appropriate given the client's needs. Now, speaking of clients' needs, what is most important to the client in this matter? Because unless we understand the client's needs, unless we're able to capture their vision, uncover their constraints, make sure that we're building the right approach, then you won't be able to effectively charge clients a price that won't cause pressure on the relationship. Now, the list of what clients are seeking in addition to the best price possible, which of course is always a factor, it's probably endless, but there's a number of usual suspects. You can use these as your prompts to drive the conversation. So if the client happens to say, well, I just want to win, or it's all about the money, I would probably dig a little deeper to find out, well, what about risk to reputation? What about, public disclosures, whatever it may be. Make sure you try to drive at some of those underlying needs and concerns that clients have, because the more that you focus on these benefits that you're going to be able to deliver to them, well, these are your value drivers, and the more value you create, then the greater price you can command. Because if we know the price you charge is higher than your client's perception of the value that you're providing, then you have automatically created resistance to hiring you or to paying the invoice. So make sure that we always ask, what are the 3 most critical outcomes, legal, business, personal, for us to deliver in the course of this matter, and what is the order of the priority of those? When it comes to hourly billing, this information is going to be your Rosetta Stone to framing why your price tag is worthwhile, and we'll talk about how to do that in just a minute. When it comes to simply doing budgets or AFAs, this step and having the answer to this question in your back pocket is mandatory, or else you're going to risk losing profitability. Our next task, quite frankly, is the simplest of these, and it is simply to determine the risk level that the client perceives as associated with this matter. Knowing this is going to assure that our price and the client's strategy are going to intersect and make financial fiscal sense for them. Clients don't like or expect to pay top dollar for routine cases or nuisance cases, whereas a bet the company matter, yeah, that's typically a win at all costs situation. So understanding where your client falls on this spectrum is going to allow you to present rates that are most aligned with their expectations, gets you closer to winning the work. Now, this is where I usually get into my first bout of resistance, because I recommend that you walk into this initial meeting with a number in hand. Now, I'm not saying that we're going to go in and offering a fixed fee in this situation, though of course that's always an option, but I get it. Not every law firm, in fact, according to BTI's research, not every client is interested in an AFA. But transparency, some level of predictability, that's been at the top of corporate counsel's wish list for the last 15 years that BTI has been tracking this market. So we don't want to just hand clients a rate sheet and hope that they don't ask for too deep of a discount. We want to make the client understand why this approach is the best for them and their unique situation. We want clients to feel good about the rate. We don't want any suicide pricing on your part. So during the discussion, walk the client through the scope of work that you anticipate for the matter. Explain how it's tied to the fees. If the scope is hard to define early on, and very frequently it is, particularly when you start getting into some of your more complex matters, address that fact bluntly and explain which factors will likely have the most impact on the costs. Now, like I said, if possible, use numbers. It makes you look more in control. Clients prefer it. Besides, clients are probably going to back you into a corner anyway to discuss numbers. So again, in the hopes of staying in charge of this conversation and directing the conversation, have the numbers ready. Now, you don't need to do a full-fledged budget projection in order to provide this information to clients. A back of the napkin calculation with, some accurate ranges is going to be just fine. We'll break out the Excel sheets and matter management systems once the firm's committed to new pricing models and driving profit margins. But for now, it can be a pretty simple calculation. And, let's go through what it looks like. We're going to give you a 2-minute budgeting lesson. I typically usually take an hour and a half to do this, but we're going to be really aggressive today. First thing that we want to do is, when we think about all of the tasks that are needed to accomplish the objectives of a matter, we want to break that work down into phases. Bigger items like the deposition, trial, motion drafting, some discrete category that the client can relate to. So this is much like those 7 deadly sins, in fact. There's a fine line between being too vague and too detailed. If you try to discuss a budget just using that one big overarching number for the whole matter, that's bad for you, because it gives you no room to negotiate or articulate all the layers of value that you're going to be providing. But again, trying to talk through every single individual task, it's tedious, and in fact, it erodes value. The client really isn't interested on how long it takes to review a document. For those of you who have been an attorney for 10 or more years, use your best judgment to assign a typical range of hours to each phase. Now, I picked 10 years not because I'm an ageist by any stretch of the imagination. I did this because it has long been an agreed upon standard for how long it takes to become a quote-unquote expert in your given domain. So as an expert, you should be able to estimate a reasonable and fairly tight range of hours for each phase of the work. Now, an important note here. Feel free to discuss with the client those situations where it's harder to predict the hours. Give them a preview of what factors could potentially bust the budget. These are usually things like jurisdictions or, aggressive opposing counsel. Do not, however, caveat every phase of the work. Writing a brief should have no caveats attached to it. We're not looking to undermine your authority as an expert at this. Now, for those of you who have been an attorney for maybe less than 10 years, same approach, take your best guess at what the hours are. You may want to run it by somebody else just to do a little bit of a gut test on your numbers, but the entire process is exactly the same. We're going to have the same conversation with the client afterwards, which is we want to be able to discuss the value of each of these phases of work. We want to make sure that we reference the value drivers that we uncovered by having that earlier conversation with the client. Now, I want to go through a quick example of this with you because I know this is a lot of methodology, and until you sort of see how it lays out, it's a little hard to understand exactly what you're supposed to be doing when you're in the room with the client. So let's say you have a client that comes to you and they tell you they have a high risk, tight turnaround matter. You smartly make the time to talk with the client before you start work, and you ask them those critical questions that we just discussed. And you discover that the three most important aspects of this case in priority order are the deadline, an intense desire to keep publicity at a minimum, and lastly is cost, because of course, cost is always a concern. Now, once you have this information, what this allows you to say to the client is, here's what I'm thinking. Let me get your thoughts on this. Now, I recommend that we use 3 senior partners because it's going to ensure that we meet that deadline. But I know that that could be pretty costly. So, I think we could probably save you some costs, maybe 10% or so, and of course you use whatever percent is accurate for the situation, by bringing in some junior folks and streamlining some of the activities in this particular process here. Now, I want you to understand, though, that the deadline is likely to be impacted if we go with this approach. It'll probably be impacted by about a week. Again, use whatever is the accurate gauge for the conversation, because there needs to be an extra layer of review, because I want to make sure that no matter what option you choose, the same high quality work and the same outcome is delivered. Now, so that's the conversation that you have with the client. The trick to having this conversation is having done your homework and being prepared with your numbers ahead of time. You know that any option you offer up to the client is going to be a profitable option. The overarching goal is to ensure that the client understands how what they want is tied to what you charge. And this conversation allows them to assess what's more important to them, costs or time. Anyway, this is a simplified example. As I mentioned at the beginning, I'm happy to talk through more specific examples on an individual basis after today's session if you want to reach out to me. Clients, what they want to know are the implications. They still want the best legal representation for the best price. So having this honest, direct conversation about costs, that positions you as this true partner and not just an attorney that's trying to get the highest rate. And that leads us to the 6th tactic for talking rates with clients. Just because a client is breathing does not mean they are worth the chase. And in fact, let me give you a quick story here, because last week I was speaking at an event, and afterwards an attorney came up to me, asked me for my opinion on how to handle reverse auctions. Now, I don't know how many of you have been involved in or experienced or heard of the reverse auction process. It rarely comes up in my experience, but it is out there. Now, this is where a client has thrown out an RFP, and the only way to respond to the RFP is by using an electronic submission, where you will put in a bid on the legal work. And much like eBay, only in reverse, you have the opportunity to underbid other competitors looking for the same work. You don't get to speak with the client. There is no discussion about value. You don't understand their objectives other than what they may or may not have outlined in the RFP. You just bid on the work and hope you get it. Each law firm participating continues to reduce their fees until it hits their minimum point and they jump out because they deem that the work is no longer chase-worthy, until there is only one firm standing and they win the work. My advice to this attorney and my advice to all of you is be the first firm to drop out. This is not a client worth pursuing, no matter how attractive the name is behind the auction. Because whether it's an auction or whether you're sitting in a room negotiating with a client who is pushing the discount down to the very last penny, this behavior is indicative of what the relationship is going to look like long term. And mark my words, these low bid clients are always the ones with the biggest grievances against the bill, even after you have made the impossible happen for them. And usually the biggest, kickback that I get from attorneys is, yeah, but this is how we get our foot in the door with the client. There's a lot of work to be had at that client organization. I think the opportunity is worth chasing. These clients never decide to start paying you more once you're on their roster, and they bid out all of their matters in the same way. So, I just urge people to really strongly consider before participating or signing on a client of this nature. Okay, now I'm going to throw in one last tactic here because I did say 6 tactics for talking rates with clients. And this one's really a little bit of a cheat on my part because it falls outside of this discussion, but it is the leading factor of why attorneys are reluctant to have a concrete discussion around costs up front. And using, those hard numbers. So please pay close attention here. You are not locked into this number. Really, if something goes to hell on the matter, you can always talk to your client about the cost implications. Even if this is a fixed fee, although if you are in a fixed fee, I recommend that you ensure that your contract has a contingency paragraph included in it. But you have room to adjust your strategies and your approaches throughout the life of a matter. It is the inherent nature of legal work that changes are going to happen. This is another reason why I recommend you conduct this discussion in terms of work phases and hour ranges, because then you have the capability to talk about which phases, again, are likely to bust the budget and which are going to be smooth sailing. We are all about trying to give the client some sense of predictability. That's all they really want. Now, what clients don't want, well, they don't want to be nickeled and dimed because that you needed to have 10 meetings instead of 5 because there was a scheduling problem, or maybe you needed to revise a document 3 times. Clients don't care about that. That's the thing that ticks them off. But clients understand new situations. They understand that new information impacts the scope that was originally planned for, and they even understand that this impacts the original budget. And now you can usually get the client to pay these new costs with little objection, as long as you follow 2 rules. The first rule is that we want to make sure that we bring up the change literally at the time that it happens. Stop working. Very literally stop working and talk to the client about the impact before you change your approach. Don't just plan on adding hours to the bill and handling the problem yourself, because those, I assure you, will be the hours that you end up writing off later. We want to be able to bring the client into the problem as soon as possible because it gets them invested in helping resolve the issue. We start talking through the options. It's very much like the conversations we had leading up to it, but now we're going to do this mid-matter instead. In light of this new information, I recommend we take X approach. That's going to have X impact on dollars. What do you think? Now it's the client's decision, and they can tell you once again, what is the priority? Is it getting back to the original cost, or is it solving the new problem that came up? The second rule in getting your clients to agree to a change in scope mid-matter is that, of course, it has to be some new information that came to light. It can't be because we missed something in the planning process. With that, I do want to thank everyone again today for joining me. I do welcome you to reach out to me directly, and my number and my email are on the screen. Feel free to reach out to me if you have specific questions.